Good morning, everyone. On behalf of Integrated Healthcare Strategies and Epstein Becker Green, we welcome and thank you for joining us for our webinar today that will discuss the spotlight on executive compensation in the healthcare industry. Your moderator today will be Robert Rife, member with Epstein Becker Green in its healthcare and life sciences practice and in its corporate services. My name is Vicki Radcliffe, and before Robert gets us started with our presentation, I'd like to review a few basic reminders and instructions for our audience. First, if you are having any issues getting online into this presentation, please call the Integrated Healthcare Strategies front desk and they may be able to assist you. That number is 612-339-0919. Please be aware that all participant lines will be muted for the entire presentation in order to reduce noise and distractions heard on the line. At the end of the presentation, we will allow time for questions and answers. If you have a question you would like addressed, you may type it in and we will read it for our presenters. To do so, please click on the Q&A button on the menu bar at the top of your screen. Type in your question and click on the Submit button, and we will do our best to get to it. Following the webinar, all participants will receive a copy of the presentation. Thank you for your patience. I'll now welcome Robert and let him take over.
Thank you, Vicki, and thank you to our attendees for participating in this program. My name is Bob Rife. I am a member of the firm of Epstein Becker and Green. By way of my background, I've been working with healthcare organizations, both for-profit and non-profit, for approximately 35 years, and have been very involved in the area, particularly of tax-exempt healthcare issues and executive compensation, and have been involved a great deal with a number of our Epstein-Becker clients in this particular area. With me today is another member of our firm, Michelle Capeza, who practices in the area of ERISA, executive compensation, and employee benefits, and represents a range of clients from Fortune 500 companies to medium-sized businesses and individual executives in these matters. In 2011, Ms. Capeza was named a Rising Star by New York Super Lawyers Metro Edition, and in 2009, she was named a Rising Star by New Jersey Super Lawyers Magazine for her work in employee benefits and ERISA. She's also been recognized in Marquis Who's Who in America and Emerging Leaders. She's also an adjunct faculty member at Seton Hall University School of Law. Also from our firm of Epstein Becker and Green, Tamar Rosenberg is a colleague of ours here located in our New York office. Her practice focuses on tax, corporate, and regulatory matters relating to tax-exempt and not-for-profit organizations. Before joining the firm, among the things that Tamar has done, she spent 4 years at KPMG in the tax-exempt organization group, advising clients on a variety of tax-exempt issues, and has experience with a wide range of not-for-profit organizations, including hospitals and other healthcare organizations and other nonprofit organizations. Joining us from Integrated Healthcare Strategies are Kevin Talbot, who is the practice leader for the Executive Compensation and Governance practice for Integrated Healthcare Strategies. He's based in Integrated Minneapolis office and has been with that firm for 8 years. His background is in executive compensation for not-for-profit hospitals and health systems, and has worked with healthcare organizations around the country, including freestanding community hospitals, large multi-hospital systems, children's hospitals, and academic medical centers. His areas of specialty include reasonableness opinions, which you'll hear a great deal about later in the program, incentive plan design, and helping boards of not-for-profit health systems with communication of executive compensation to external stockholders. Also from Integrated Healthcare Strategies is Mark Wade, Senior Vice President in the Executive Compensation and Governance practice of Integrated Healthcare and works out of the firm's Dallas office. Mark has over 20 years of consulting and industry experience, and has assisted hospital boards, equity investors, and executive committees with overall compensation and benefit strategy and program design, not-for-profit reasonableness opinions, short and long-term incentive plan design, and mergers and acquisitions. And although Mark has been with Integrated Healthcare Strategies for a little less than a year, prior to his joining that firm, he was with two national consulting firms and most recently Vice President of Total Reward at Baylor Healthcare Systems. So that's the panel that will be discussing this very important topic today. By way of background, let me offer a few opening remarks about what we hope to accomplish today. And for those of you who have been in this industry for some period of time, you'll recall that although there is a current spotlight on executive compensation generally, whether it's for-profit or non-profit, in the area of non-profit spotlight, one could almost say that that spotlight began to shine back in the late 80s and early 90s. There were a number of what I would describe as public relations disasters for a number of nonprofit healthcare systems who received publicity through their local print media on the compensation of CEOs. In one particular instance, a CEO, as part of his compensation plan, the healthcare system paid for his boat dock on a particularly large lake. And so a lot of scrutiny has been applied to this particular area and this particular industry as far back as I say, the early 80s and 90s. And back then, when that issue became one, again, under the microscope, that microscope identified the fact that the principal regulatory body in this area, the Internal Revenue Service, really did not have the tools available to it to scrutinize excuse me, these kinds of executive compensation decision-making. In fact, if you recall the hearings that Congress held with IRS representatives, the only tool that existed prior to 1996 that the IRS had in the area of executive compensation or any type of transaction that was not reasonable was revocation of the tax-exempt status. And when asked excuse me, how frequently that had occurred since the enactment of the 1954 Internal Revenue Code, the answer was somewhere between 5 and 10 in that 40-year or 35 to 40-year period. So Congress, in its oversight role and its legislative role, did again shine a spotlight on that whole issue and crafted a regulatory scheme, which you'll hear about more in our presentation. And for many years following that, although there's been public relations issues relating to disclosure and things like that, it was only, again, in the early part of this century, in the first decade, that we saw a renewed area of examination, excuse me, particularly on the state level. And you saw some state attorneys general really examining the issue of compensation. And in at least one case here in New York State, the then state attorney general attacked a compensation, actually a severance arrangement with the CEO of the National Association of Securities Dealers, NASDAQ, system before it converted to for-profit, claiming that under New York State corporate law, the compensation and severance program was unreasonable. That case, both on its merits and on a technical matter, was lost, but the issue of executive compensation remains very much in the forefront of today's federal and state regulators. And lastly, as many of you know, there's been a greater shift in emphasis in terms of examining compensation generally, with the enactment starting with Sarbanes-Oxley in 2002, and then the recent enactment of the Dodd-Frank Act. And although those focus on specific for-profit companies, the activities that they scrutinize are quickly becoming identified as best practices in the not-for-profit arena. As a consequence, there's really an intense amount of focus on disclosure and testing of executive compensation in healthcare. And with that as the introduction, I'm going to turn it over to Kevin for him to begin the presentation.
Good morning or good afternoon to everyone, depending on where you're dialing from this morning. It's a pleasure to be with you all. I want to begin by setting the stage with regards to some of the key factors influencing executive pay in healthcare right now, not the least of which obviously is the economy, where we're now 3 years into the economic downturn, coupled with high rates of unemployment, with federal and state budget constraints, and as Bob alluded to, an overall negative perception of executive pay, both from the regulators and from the public, in the wake of some of the more recent issues we've seen in executive compensation outside of healthcare. Compounding this is the likelihood that going forward there will be more regulation coming from, first of all, healthcare reform. We're looking at a significant evolution of healthcare under the recent reform bills, and a lot of activity at the federal, state, and local level, which we'll talk in more detail about later.
In the meeting.
Some of the likely outcomes of healthcare reform are going to be more true integrated delivery systems with finance and insuring risk-taking, ACO-like organizations. With that, we expect a greater level of physician involvement in governance and leadership, an elevated role of the physician leader, and consequently changes in how those individuals in a leadership role, in executive role, are paid within these emerging organizations. More mergers, larger statewide and regional health systems, again influencing ultimately pay, and then tighter margins and reimbursement. These are all factors that will not only influence, we think, the amount of pay, but probably more importantly, how pay is provided to executives and leaders within that organization. Now, I want to be careful here to make sure we're all using common terminology. Throughout this presentation, you may hear us refer to pay for performance or incentives. In almost all those cases, we will be referring to, unless we say otherwise, what I'll call internal pay for performance as opposed to external pay for performance. External pay for performance being how health systems, health organizations may be reimbursed based on their own performance versus internal pay performance, how executives are paid and compensated based on their performance or their organization's performance. Now, I'd like to share with you some data on how some of these things are actually impacting pay right now, and actually over the last couple of years for executives in healthcare. Beginning in late 2008 through 2009 and 2010, we saw a significant decrease in what had been a fairly predictable level of increase in executive salaries in the healthcare industry, dropping from roughly 4% on average to about 2.5% through the past 2 years. In 2011, we've seen a slight uptick. Our own surveys and many other industry surveys out there looking at 2.8 to 3% range in 2011. We expect that to continue through 2011 based on what we see in terms of budgets and planning for the coming year. There are certainly hot jobs out there that are increasing at a more rapid rate, namely information technology positions, finance, and medical practice management positions. As you can imagine, more and more organizations, as you're probably well aware of and may be involved in yourself, are either acquiring physician practices, employing physicians directly. As these organizations within larger healthcare systems grow, they will need leaders to help manage and lead those physician organizations, and it is certainly a high demand position for talented leadership there and an evolving pay practices. Incentive compensation remains a very prominent part of executive pay in healthcare. Most not-for-profit hospitals and health systems have performance-based incentives for their executives that are annual incentives. A much smaller percent, fewer than 25% of the overall industry, has long-term incentives. The recent award payouts in the past couple of years have been a little bit lower than what we've seen in the past, below what we would call target or ARM plan levels, mainly because many systems have faced some tough financial challenges. And most of the incentive plans we see out there have financial metrics. Interestingly enough, one of the trends we've seen for a number of years is a greater emphasis on non-financial measures, particularly clinical quality, patient satisfaction, and more recently, areas like community benefit and physician alignment. Just briefly on some other elements of pay, and you'll hear us speak about the importance of, from a regulatory, from a compliance and reasonable standpoint, looking at all elements of pay. Benefits, we've seen some organizations looking to control costs around benefits, but overall we haven't seen a significant change in expenditure levels for executive benefits. Perquisites are slowly disappearing. They are highly visible, highly inflammatory in the media. They make up a small percentage of overall pay. Many organizations are saying it's not worth the headache or the public image risk of having them, and are either eliminating and rolling them into base pay or providing allowances. If there's a business need for them, certainly they can be justified. And finally, severance is a hot button issue in today's economy. Boards are becoming more cautious, but reasonable severance is still acceptable. Now I'm going to pass to Bob.
Thanks. What we're going to talk about now is the federal and state governmental initiatives of executive compensation for healthcare organizations. What you've heard so far is really sort of predictive of where the industry is going, some of the pressures that will be felt. As was mentioned, there's going to be an incredible amount of pressure, particularly in the area of reimbursement. I think I saw some data yesterday that suggests with proposed cuts to Medicare and Medicaid, hospital margins are expected to drop significantly. And one of the things that we'll talk about a little bit later is the whole area of performance measurements and whether or not they're tied strictly to profitability versus quality and other kinds of performance incentives. But right now I'm going to ask Tamar to talk a little bit about some of the initiatives both on the federal and state level that are currently outstanding and have raised particular issues for a number of nonprofit healthcare companies around the country. Tamar?
Thank you, Bob. There have been a lot of developments recently in different states in terms of executive compensation for nonprofits. One of the biggest efforts right now is in New York, where Governor Cuomo formed a task force to investigate executive compensation at nonprofits that receive state funding. Governor Cuomo announced a task force in August, just one day after the New York Times ran an article about a nonprofit organization that serves the developmentally disabled in New York and received Medicaid funding and paid its top 2 executives close to $1 million a year each. The organization also provided its executives with luxury cars, paid their children's tuition, and even helped buy an apartment for one of their kids. The task force is charged not only with investigating compensation, but also with making recommendations for new rules to ensure that taxpayer dollars are not used to pay excessive salaries. The task force got to work right away and has been sending letters to hundreds of organizations asking for a lot of data on compensation from the past few years. The spokesman for the task force has said that all nonprofits in the state that receive state funding will eventually receive the task force's request for information. The information requested in the task force's letter is similar, but it's not identical to the information on the IRS Form 990, which is really important because the responses to the task force will probably be open to the public under the state's Freedom of Information law, so that salaries of employees that were never open to the public before could now become public information. You might also be interested in knowing that we've heard that certain hospital industry associations have reached an informal agreement with the task force to reduce the number of questions that the hospitals are required to answer and to limit the scope of employees whose compensation has to be disclosed. Massachusetts has also been very active lately in scrutinizing nonprofit compensation. There's proposed legislation right now that would cap executive compensation at nonprofits that are considered public charities under state law at $500,000 a year. The bill would allow for waivers, but only if you can convince a special commission that includes the Attorney General that there's good reason for it. The same bill would also impose state-level financial and other penalties for engaging in an excess benefit transaction under federal law, which we'll talk about a little bit later, but which includes paying excessive compensation. These penalties would be on top of any penalties imposed by the IRS. Massachusetts also has another bill pending right now that would prohibit public charities from paying their board members without advance approval from the Attorney General's office. This bill came on the heels of an investigation by the Attorney General of the compensation paid to board members of Massachusetts' 4 major nonprofit health insurers, in which the Attorney General concluded that there was no justification for paying them. The letter describing why the Attorney General rejected the different arguments made by the insurers to justify paying their board members is posted on the Attorney General's website. The Massachusetts Attorney General also recently reviewed a $4 million severance package paid to the president and CEO of a nonprofit health insurer who was terminated because the board lost confidence in his performance. The Attorney General publicized a letter describing its review of his compensation and severance arrangements. The letter includes that certain severance provisions that have become very common don't really serve the purpose for which they're intended and may waste the organization's charitable assets and have other negative consequences. A few different states have also recently had bills that would cap executive compensation in different ways. Maine and Rhode Island recently had proposals to limit compensation for hospital administrators, and California proposed to limit compensation for certain state college presidents, but none of those bills passed. New York, however, still has an active bill in the legislature that would cap executive pay at publicly financed hospitals to $250,000 a year. A few other states, such as Vermont, North Carolina, and New Hampshire, have also seen similar efforts. New Jersey also made a similar effort. Contracts with certain social service providers in New Jersey now require that state funds can be used to pay executive compensation only up to certain amounts. The amounts vary based on the size of the organization, but the highest amount is for organizations whose gross revenue is over $20 million a year, and the cap is only $141,000. The state contracts also impose other similar related rules, such as capping physician compensation and business travel expenses. A lot has also been going on over the past few years at the federal level to investigate and regulate nonprofit executive compensation. One of the most important efforts is that the IRS conducted compliance checks on the topics of executive compensation and also on various tax-exempt issues for both hospitals and universities. In a compliance check, the IRS sends questionnaires to hundreds or thousands of organizations, conducts a limited number of audits, and issues a final report with its conclusions. The IRS also recently revised the Form 990, the annual nonprofit tax return, to require disclosure of much more detailed executive compensation information, as well as a lot of other information. Over the past several years, we've also seen different committees of Congress conducting various hearings on different topics for nonprofits, including executive compensation. Certain political leaders have also taken it upon themselves to act on their own to look at nonprofits and to question some of their practices. Most recently, Senator Grassley of Iowa called for the elimination of the safe harbor under the tax law to establish a rebuttable presumption that compensation is reasonable and to eliminate the special exception provided for new contracts. Also, a congressman from Louisiana recently sent a letter, really just at the end of October, to the IRS commissioner asking for an explanation of how the IRS oversees nonprofits, how it's using the information from the new 990 to enhance tax compliance, and how it will improve compliance in general going forward. I also want to add that all of these developments that we're talking about at the federal and state level in executive compensation really seem to be part of a larger trend to look at tax-exempt organizations and to hold them accountable for how they use their assets, and to see that they're giving enough benefits back to society to justify the special privilege of tax exemption, especially at a time when taxpayer dollars are so tight. Finally, I just want to add that if anyone on the webinar today would like more information about any of these state or federal developments that we went through pretty quickly, just let me know. I'm happy to send you additional information.
Thank you, Tamara. And I actually also want to emphasize the last part of what Tamara was saying. Much of what you heard in the presentation focused on a number of key states, particularly here on the East, but the area of state revenue generation from nonprofits through the guise of re-examining tax-exempt behavior has become a very hot topic. Certainly, Illinois tried to do it, although the governor has, for now, temporarily suspended that effort. And other states, I believe Texas is also looking at that area. There's been a lot of publicity nationwide on a state-by-state basis. And frankly, it should come as no surprise to the listeners that as state budgets become more and more constrained, and municipal budgets, looking for opportunities to limit or to expand the tax-paying base will become a key component for many governmental agencies. What I'd like to do now is move on to our next topic, which is board and officer responsibility, and particularly board responsibility and liability for executive compensation of healthcare not-for-profit organizations. One of the key elements that has gone into much of the development of this area of the law has really been the whole notion of what is the responsibility of a board of directors. And that's commonly been referred to as the issue of what is the fiduciary duty of directors. And so even before the IRS became involved or began scrutinizing through enhanced 990 reporting and other audit activities, fundamentally the board of directors, or the board of trustees as is known in many parts of the country, really has established historic responsibility for running an organization, be it a nonprofit or for-profit, in a way that is in, quote, the best interest of the entity and not in the best personal interest of individuals. While historically enforcement on the tax-exempt side has obviously been with the IRS, many state attorneys general have also from time to time focused on the area of nonprofit decision-making, particularly in egregious circumstances. So, for example, there's a long list of transactional activities that healthcare organizations were undertaking back in the late 70s and early 80s that were scrutinized by various attorneys general when they were converting from nonprofit to for-profit and the method by which that was being undertaken. In addition, oftentimes transactions involving nonprofit and for-profit organizations have looked at the area of compensation and golden parachutes to really focus on that. A good example, if many of you might recall, a number of years ago, the then Blue Cross licensee in Ohio was proposing to convert to for-profit, and the state attorney general not only rejected that conversion, but the Blue Cross Association stripped that insurance company of its license because of the nature of compensation being paid not only to the CEO but board members. And that really is fundamentally the issue of what is the responsibility of directors and officers in this particular area. As I mentioned in my introductory remarks, one state in particular, New York, does have in its corporate law a reasonableness standard for compensation in nonprofits. It's only been, to my knowledge, litigated that one instance, and there, although it was determined procedurally to be mooted by the fact that the entity, the corporation, converted to a for-profit, there was some writing by the court examining that even though it was a fairly large compensation package, I believe over $110 million, that still might have been reasonable in the context of that organization. Nevertheless, it has become an area of scrutiny. Well, what does that exactly mean, and what should boards be doing? Basically, there are fundamental best practices that a board should be utilizing in this area and generally in the oversight of a nonprofit corporation. In those areas, you look to the certificate of incorporation, sometimes referred to as the articles of incorporation in various states, the bylaws of the organization, the board compensation committee, a key committee of the organization, and you'll hear more in a little bit about how that committee and the role of the board under the IRS, what's called the rebuttable presumption, has now become a key element. But even before the enactment of that in 1996, the board then had and continue to have a rule to exercise their judgment, although it's called the business judgment rule, to exercise their judgment and decision-making authority in the best interest of the corporation. And so you've got a board compensation committee, conflict of interest policies, compensation policies, and philosophy, many of which things arise from the development of best practices out of the Taxpayers' Bill of Rights, the Excise Benefit Transaction Statute, but in general really have as their fundamental underpinning basic corporate good governance provisions. While there are state and to some extent limited federal limitation, mostly looking at state law, the states all have, for the most part, the following general concepts. One is that if a board of directors acts reasonably, its activities will not be second-guessed by third parties. And you might ask, well, how does that apply to a nonprofit corporation? Certainly understandable. In a for-profit corporation, we hear about shareholders suing boards all the time. Who gets to do that in a nonprofit? Well, there are two categories of potential litigants there. One is if you are a member organization, you have members. In many states, the members have rights akin to shareholders in this particular area. Beyond that, however, although it may not be effectively utilized, the various states' attorney general powers do include oversight of charities. And the attorney general, as was the case here in New York, but in other locales, does have that inherent power to oversee how a charity's assets are being utilized. So there is some scrutiny. On the flip side, however, most states have now enacted statutes in their corporate code that limit the liability, the personal liability of directors, unless their conduct is outside of even negligence as a standard. It's really got to be willful or grossly negligent behavior to subject someone to personal liability outside of the tax provisions, which you'll hear about. So for the most part, on a corporate basis, if a board acts as a reasonable board, exercising its fiduciary duty as a reasonable group of people under the same circumstances, that is the business judgment rule, that should be sufficient on a state law basis, subject to some of these other things that you'll hear. What you're now seeing, however, briefly speaking, is this new area, and that is the area of recent legislation on a for-profit level, namely Sarbanes-Oxley and Dodd-Frank, that have given rise to best practices even at the nonprofit level. And you'll see that directors should be active participants in oversight, not mere passive recipients of information. They need to be, we use this phrase, rattle cages when necessary. Directors are appointed and should be appointed to your boards of directors, not simply because they're important in the community, they're important for fundraising, they represent a particular constituency, but really have the skill set necessary to be effective leaders of this organization. So rattling cages is important. Reasonable knowledge is very, very important. A board should not be passive. Again, you'll hear about some of the things that tax law imposes, but as a board should nevertheless be foremost as a best practice, even outside of the tax requirements. Now I'm going to turn it over to Michelle to really talk a little bit more about kind of the intersection of the excess benefit transaction rules in Section 4958 and what I was just describing as the fundamental responsibility of a board. Michelle?
Thanks, Bob. Well, in 1996, the Internal Revenue Code was amended to add Section 4958, which applies to nonprofit organizations who engage in transactions that inure to the benefit of the so-called disqualified persons within the organization. The intermediate sanctions can be imposed on any disqualified person who receives an excess benefit from the organization and on each organization manager who approves the excess benefit. So the excess benefit essentially is conveyed when the entity is not receiving consideration from the individual providing services that is commensurate with its payment of compensation, which results in payment of excessive compensation. In other words, the compensation should not exceed the fair market value of the services the organization receives in return. The disqualified individuals include those who, during a 5-year look-back period ending on the date of the transaction in question, were in a position to exercise substantial influence over the affairs of the exempt organization. This includes voting board members, president, CEO, COO, and CFOs. It can also include another organization, partnership, trust, or estate, and family members of disqualified persons, or organizations owned 35% or more by the disqualified person. Others may also be considered disqualified persons under a facts and circumstances test concerning whether they have substantial influence over the affairs of the organization. So So integral to the analysis as to whether intermediate sanctions will apply concerns whether the compensation paid was reasonable. In determining what compensation has been paid to a disqualified person, you must consider all compensation paid by the tax-exempt entity in exchange for the performance of services. Exceptions to the elements of compensation that do not need to be counted include non-taxable fringe benefits under Section 132 of the Code, such as accident and health benefits, tuition reimbursements, dependent care assistance, and items of that nature. Another exception includes certain fixed payments made to a person under an initial contract where the person was not a disqualified person immediately prior to entering into the contract. As I will mention in an upcoming slide, the reasonableness is determined based on a fair market value analysis. Ooh. So a failure to pay reasonable compensation can trigger significant income tax penalties to the executive who received the overpayment and to certain managers within the organization who approve the excessive compensation. There's a 25% penalty imposed on the amount of the excess benefit, and if the transaction is not reversed before the earlier of the date of the mailing of a notice of deficiency concerning that initial tax, or the date when the IRS assesses the 25% initial tax, a 200% additional penalty may be levied. Any organization managers who knowingly and willingly approve the transaction can be subject to a 10% tax, that is 10% of the excess benefit. In addition, the entity's tax-exempt status can also be jeopardized. So in order to avoid these penalties, the Treasury regulations do provide a rebuttable presumption that most organizations follow to establish that their determination of executive compensation is reasonable and at a fair market value. The procedure requires that the tax-exempt entity have the organization's governing body or a committee of that body composed of individuals who do not have a conflict of interest with respect to the transaction approve the executive compensation in advance. A conflict of interest can arise if the committee member is a disqualified person or related to one, or receives their own compensation subject to approval of a disqualified person, or has a financial interest in the compensation determination, for example. In addition, the committee should obtain and base its decisions on comparability data. For example, data concerning compensation levels paid by similarly situated organizations for similar positions, availability of similar services in the same area of the exempt organization, independent compensation surveys from independent firms, and actual written offers of those competing for services of the disqualified person. In addition, legislative history to these rules provides that for-profit comparability data may also be relevant and used for this purpose. And the committee must sufficiently and contemporaneously document the basis for its determinations of executive compensation. The IRS can rebut the presumption of reasonableness only if it can develop sufficient contrary evidence to challenge the probative value of the comparability data relied upon by the authorized body. As executive compensation comes under increased scrutiny and the landscape continues to change, the continued availability of the rebuttable presumption should be monitored. So where can legal counsel add value and assist you in these responsibilities? Well, certainly legal counsel can assist in various aspects of compliance in this area. We can certainly assist in navigating the myriad of laws and regulations in this area, aid in the design of deferred compensation, notably in achieving compliance with 409A and 457 of the tax code, as well as designing incentive programs and retirement plans if you are audited. We can also assist in answering the auditors or assist in preparing an organization for an audit. We can assist in advising, reviewing, and preparing organizational governing documents, resolutions and committee charters, as well as training personnel to be aware of their duties, how to properly execute them, and avoid conflicts of interest. We can assist with compliance in connection with completion of the Form 990, especially with regard to the disclosure concerning whether the process used to determine the compensation of the organization's top management officials and other officers and key employees included a review and approval of independent persons, review of comparability data, and contemporaneous substantiation of the deliberation and decision. And certainly we can advise the organization's board or compensation committee with respect to its duties and laws affecting its decision making. I would like to turn it over now to Mark, who will discuss the view from the consultant.
Thanks. Bob and Michelle have done a great job in outlining the responsibilities and establishing the presumption of reasonableness. But as you can see, there are still quite a few gray areas, but most of these focus around independence, boards making solid decisions based upon a justifiable rationale. For this reason, many hospitals and healthcare systems engage compensation consultants to assist them with this process. Some of the benefits that outside consultants bring is independence from management. While there's always interaction with management at some level, the outside consultants are hired by the board and then allows the board to remain independent in making their decisions. Again, as Michelle mentioned, you need to be able to define reasonableness and reasonable compensation. So in doing this, the compensation consultants can offer certified opinions that will help you in establishing that presumption. Again, another area that is surprising to see how few hospitals actually have a written comp philosophy that's adopted by the board, but compensation consultants can help you develop that effective compensation philosophy. The benefits of this is it ensures your compensation supports the mission, vision, and values of the organization. It outlines your salary mix, which includes base salary, incentive, and other benefits. And then it helps the board attract and recruit and retain executives. And most importantly, it establishes ahead of time how and why the board of directors makes certain compensation decisions. Compensation consultants also have access to industry trends and best practices. Given the changing landscape in healthcare, this can greatly assist the boards in making these compensation decisions that will help them move to the next generation of healthcare reform. Also, we can help boards prepare for dealing with public relations and media relations issues. No one wants to end up on the front page of a paper because of a compensation issue. So having the compensation consultant work with the board, you can establish a proactive communication strategy so when you get the call, you know who's going to say what and what the consistent answer is going to be. And again, we'll touch on this a little bit more later, but the compensation consultants bringing the best practice can help develop incentive plans and deferred compensation programs that will allow your organization to be competitive and recruit and retain executive talent. So with that, I will turn this back over to Bob, and we'll move to the next topic.
Thanks, Mark. Just to kind of summarize where we've been so far, you'll see a consistent message and description of what best practices really are all about, starting with the underpinnings of corporate good governance, how a board of directors should operate. Where does the Section 4958 fit into it? What are the respective roles that bring together the knowledge base, the data, the information that a board should have as it makes compensation decisions? All of those really become the building blocks, one on top of the other. Again, starting with just basic corporate fiduciary duty, acting in the best interest of the corporation, using the rebuttable presumption in a way that shifts to the IRS the obligation to overcome the presumption that compensation was unreasonable, but the various parts to that, the collection of data, the advice of consultants, all of that become part of this next topic, best practices of not-for-profit healthcare organizations. So what you really have, and I'm going to just turn it over more to a generalized discussion at the moment of what are the kinds of things that we would recommend as counsel to a nonprofit, and what are the kinds of things that our colleagues at Integrated Healthcare Strategies would recommend. You'll see on this next set of slides some of our recommendations, and Mark or Kevin, you want to talk a little bit about what we've got here in terms of recommendations?
Sure. This is Kevin, and a couple key points in terms of best practices. You need to make sure that the full board is getting periodic reports on what decisions have been made in compliance with board policy and philosophy. We also think, as a best practice, annually the board should be getting education around these issues. You and I and many of us on the phone live this day in and day out. Your board members, committee members do not. They need to have continuous education to keep this front and center, periodically reviewing the authority of the board of directors to the compensation committee to ensure that the committee is in fact fully independent. We talked about the importance of that independence and mentioning that the full board should receive a copy of the Form 990. The other issue there is your committee itself. Even if your board is reviewing the Form 990, your committee should be looking at least the compensation portion of that 990 to understand what numbers are going on it, to make sure it aligns with what they're hearing from their compensation consultant. And as Mark mentioned earlier, they understand what's going to be out there publicly available so they can prepare a response. I also suggest that you look at not only your own 990s, but those of your competitors in the immediate area. And we'll touch a little bit more on some of that later.
Yeah, and let me just add a couple of things, and I will give you a war story of a client with whom I've been working almost 15 years as both counsel to and corporate secretary to their executive compensation committee. And what you've heard to date are really the key best practices. Having a compensation philosophy, a conflict of interest policy, the criticality of having outside data, and interestingly enough, if you dive deeply into the legislative history of 4958 and the excess benefit transaction rules, you'll see that although there is a preference for comparable data on a nonprofit basis, the legislative history makes clear that that's not always going to be possible, and looking at for-profit data is also permissible, primarily because there's a challenge to compare stock options and stock-based, equity-based compensation to what a nonprofit can do. So utilizing that is of key importance. Again, as Kevin was saying, the board or a designated portion of the board ought to receive a copy of the 990 and should really scrutinize it. It's not simply here's a copy of what is intended to be filed, but there should be challenges. Your board should be educated and sufficiently sophisticated to be able to challenge what management is putting into the 990, because ultimately the body that is scrutinized here is the board of directors. Some other best practices, and Kevin, you want to talk a little bit about these as well?
Yeah, we've touched on some of these. A couple practical issues around, first of all, your compensation committee, your independent committee. Make sure, as a reminder, they're not looking just at CEO pay, but all executive or really all disqualified individuals' pay. For a large health system, a large organization, that can be very time-consuming. That can be a lot of data for them to look at, which leads to the next point of make sure you're scheduling enough meetings and scheduling them at the right time so that you can adequately establish the rebuttable presumption of reasonableness. Not only is the amount of time critical, you're looking at decisions ranging from, well, first of all, absorbing all the data, understanding it, deciding about base salary adjustments, reviewing incentive plan goals potentially, and the determination of awards at the end of a performance cycle. A lot of decision points. You need to make sure the meetings are scheduled such that you can have those approved by the committee for the disqualified individuals prior to implementing those decisions. So you have to coordinate that with your administration cycle. The other point to make is, the importance of the charter and ensuring that it not only describes your process but lays out the qualifications. Bob mentioned the need for knowledge, but also having trustees who have the ability to really challenge and understand what's going on. Next slide. we talked a little bit about a compensation philosophy. What do I mean by a compensation philosophy? We believe it's a best practice, and in fact, most organizations are already doing this, that you have a formal written document that talks about your philosophy. What should go in that philosophy, first of all, is not only how much you pay at what level relative to the marketplace, but it should be defining your peer group, for example. Are you looking at a national peer group, organizations from around the country? What are those types of organizations? How are you defining them? By size, by type of organization? If you are, for example, a children's hospital, should you be looking at general acute care hospitals or children's hospitals when you're thinking about your peer group? Where do you recruit and retain? What are the comparable jobs like throughout the industry? Should you be looking at just not-for-profit or for-profit? What data sources you'll be relying upon, and then the mix of pay, not only the levels, but how you're providing it. I want to just spend a little bit of time talking about pay for performance or incentives. We talked about the prevalence of annual and long-term incentives. As a committee, not only figuring out how much, but what are the criteria, what is the expectation of performance for the payment of award. It should not be based solely on financial performance. Yes, financial performance should be included. Oftentimes it's a trigger, a minimum hurdle needs to be achieved before any awards are earned, but there needs to be clinical quality metrics, there needs to be patient satisfaction. More and more frequently we are seeing what I'll call physician alignment measures as you see organizations going out, getting more engaged in bringing on medical groups. If that's part of their strategy, the success of that should be built into the incentive programs. And then finally, I think a good philosophy needs to have some flexibility so that you can make exceptions or deal with exceptions, not just have to make exceptions to rules. So one last thing on philosophy, make sure you're reviewing that on a regular basis. It should be a living document. And then finally, as far as what organizations are doing with their philosophy, it should come as no surprise that the most common philosophy, about half of all organizations out there have what we'll call a median philosophy. We pay salaries at the median, we pay average incentives and benefits, so total compensation targeted at the median. That's really, though, interestingly enough, the floor. Very few organizations, virtually none, with a couple exceptions, will have a philosophy that says we intend to pay below median, because that's not a good way to recruit and retain. Now, they may practice be doing that, but their philosophy is not going to state that. Therefore, the other half of organizations out there have a philosophy that has them targeting something above median, 60 to 75th percentile, and oftentimes with incentive-based pay, if you're targeting the 75th percentile, that allows for actual pay to be above or below that level depending on performance. So that's just a little bit of food for thought as you're thinking through your own philosophies on how you align yours and what that means to the rest of your peers.
Taking a look at some of the other best practices, and this you would think is stating the obvious, but you really need to focus on total compensation. It goes without saying that you need reliable data from like organizations, but you can't just focus on the base compensation. You need to take a look at the value of incentives, benefits, perquisites, supplemental plans, etc. Number two, document any rationale for exceptions. Kevin has talked about the importance of having a written compensation philosophy, but there are always going to be exceptions, and that's where facts and circumstances come into play. So it's very important that these be evaluated and clearly documented in the board minutes what the rationale for the exception was. Evaluate enhancements in advance as it relates to total compensation. This can be adding a particular benefit, maybe changing to a benefit such as a vesting schedule in a SERP, adding a potential severance payment. So looking at that as it relates to total compensation in advance, and again making sure that the board has the knowledge of that and what the value of that is going to be. And using the same compensation consultant to evaluate the aspects of executive compensation. We're not saying that you need to use the same consultant for everything around human resources, but when it comes to executive compensation, you need to have one voice and all your advisors need to collaborate to ensure a consistent message. An example would be, for example, the value of a supplemental retirement plan. You don't want your actuaries to come up with one value and then your comp consultant coming up with another value for the definition of reasonableness. And then at board meetings, annually present tally sheets to the board to quantify the total compensation. Surprisingly, these are not always used. It's basically as simple as showing a side-by-side comparison of all plans, base, incentive, and benefits, and how that compares to market. This will clearly allow the board to know what decisions they're making and how this is, what they're based upon. Also, looking at the process, this really should be looked at every few years. We have clients who take a high-level look every year and do a full review every 2 or 3 years. Some do a full review every year. The basic point is you can't do this once every 5 to 7 years and then expect to be able to rely on it. Using a consultant to gather data on competitive practices and not staff. This is not saying that the staff isn't competent to do this, but again, one of the important components is board independence. And so the consultant allows the board to remain independent and often has more resources as far as best practice and data. The committee should meet regularly in executive session. They need to be able to speak freely and make decisions without fear of reprisal. I skipped one. That the committee should hire and supervise this consultant directly. This is actually an area that can get very touchy. Sometimes you have, again, as I mentioned earlier, you will have interaction with the executive team, but it is not uncommon for executives to want to drive part of the process, even sometimes to the point of wanting to have editorial rights on the reports. It's very important that the consultant convey to the executives and keep reminding them that they work for the board. Again, decisions must be adequately documented in the minutes, and the committee should report all of their findings to the full board. One thing as far as documentation in the minutes, it's important to recognize that minutes are not necessarily a transcript where you're taking down what every individual said. It's also important to know who is responsible for capturing minutes of the meeting. I've been in meetings where that was not adequately conveyed, and 2 to 3 weeks later, either general counsel or vice president of HR is calling saying, do you remember what the final outcome of this decision was? So it's important to understand whose job it is to capture this. Some of the basic things that are very important as the board meets to establish this presumption, they need to state that they have the intent to establish the presumption of reasonableness. They need to identify who was present and measured deliberations and the vote. They state that there's not a conflict of interest for all those that are present. They need to show the sources of comparability for like jobs and like organizations, and mention that the committee relied on that comparability data for making the decisions. The minutes should state the terms of the compensation that was approved, and that the statement that the directors believe that what was approved represents a fair market value, and again, what was the rationale for any exceptions that might have been made that were not consistent with the compensation philosophy, and get those documented in the minutes. Finally, we spoke about this a little bit before, but having a proactive communication strategy to understand how you're going to respond to potential inquiries. With the public scrutiny around executive compensation, it's not uncommon around 9/90 time to start getting calls from the press and having salary information end up in the paper. You need a proactive strategy to determine who's going to respond and how they're going to respond, and it typically should not be one of the executives or the CEO. They shouldn't be put in a position where they're justifying their compensation. So how are you going to respond, and are you ready for the questions? And then again, that also can apply from a compensation philosophy, a communication strategy on how are you going to respond to some of the legally required documents and what level of transparency are you going to provide, for example, in the 990? Having that established up front is, will again assist in developing that, the intent to establish reasonableness. And with that, I'm going to turn it back to Bob for topic 4.
Thanks, Kevin and Mark. What we're going to talk a little bit about, and I'm going to ask Michelle to talk about, is special compensation issues affecting for-profit. And although this program was geared to nonprofit, as we all know, with the advent of compensation requirements affecting for-profit, the advent of Sarbanes-Oxley and Dodd-Frank, over time, and time is always relative, those activities are often trumpeted as best practices, even though a particular nonprofit is obviously not subject to those requirements and those limitations. Over time, what the industry has seen and what we've seen as in our collective experiences, those things nevertheless become touchstones for nonprofits. So with that as somewhat the rationale for why we're going to talk a little bit about healthcare for-profit organizations, I'm going to turn it over to Michelle.
Thanks, Bob. Over the past several years, especially since the days of Enron, we have seen sweeping regulation in the area of executive compensation. Certainly, the financial industry has been hit with numerous regulations, especially among those that receive TARP funds. The healthcare system is also under scrutiny with health reform and increasing scrutiny for their executive pay practices. Anticipated trends include more controls on the pay of executives in the healthcare industry as a way to control the cost of healthcare. While the Dodd-Frank Wall Street Reform and Consumer Protection Act, enacted in July 2010, set forth many requirements impacting executive compensation of public companies, many view these rules as having a future spillover effect, impacting all sectors of the healthcare industry, and its concepts are worthy of introduction to compensation committees in all industries and sectors. Just to give you an idea of some of these concepts and rules of which you should be aware, a few examples include the following. Dodd-Frank requires disclosure of pay disparity, illustrated by the ratio of public company CEO annual total compensation to the median annual total compensation of all other employees. This rule has been very controversial, as it has been argued that compliance will be unduly burdensome and will not necessarily yield any useful information. It will require time to integrate payroll and deal with international data privacy issues. It remains to be seen what the final rules will provide in this area. It is suggested that all companies monitor pay relationships within their organizations to avoid unreasonableness and to be prepared to answer any public media questions in that regard. Dodd-Frank also requires the independence of compensation committee members. Independence will be determined based on how the member is paid and any affiliations of the member with the company. There are also rules about the committee retaining independent advisors and consultants independent of those who otherwise advise the company. These rules are intended to mitigate risk or conflict of interest by professionals advising compensation committees on matters relating to executive compensation. This rule sounds very familiar to the independent standards set forth under the IRS Intermediate Sanction Regulations, which we have all discussed today. Say on pay is another requirement that requires at least once every 3 years the company include in a proxy statement a resolution subject to a non-binding vote of shareholders to approve the compensation of the named executive officer, and at least once every 6 years seek a shareholder vote on frequency as to whether the say on pay vote should occur every 1, 2, or 3 years. Any merger proxy statement must include a non-binding shareholder vote to approve named executive officer compensation related to the transaction, unless that was previously voted on. Although these votes are non-binding, it's anticipated that the desire to avoid no votes will impact future compensation practices. It is also possible that if these rules were to become required throughout the healthcare industry, they could conceivably afford a say-on-pay vote to policyholders of mutual companies, members of HMOs, and possibly even stakeholders of nonprofit providers. The clawback is another provision that requires public companies to develop and implement policy to recapture compensation that is erroneously awarded to executives prior to a restatement of the company's financial statements. This requirement is mandatory, covers all present and former executive officers, and does not require misconduct by the company or any officer as a condition to invoking the clawback. What is new here is the idea of clawing back incentive compensation enhanced by a financial misstatement without regard to the executive's participation in the misstatement. There's still a debate whether clawbacks are lawful under varying state wage laws that protect employees from unlawful deductions of their wages. It remains to be seen the extent to which federal preemption may apply to these state laws, but clawbacks are increasingly becoming part of prudent governance, and an organization's ability to recoup payments made to executives in error is becoming ever more critical. The SEC has an aggressive schedule for implementing Dodd-Frank provisions in the first half of 2012. We do anticipate rules to be issued on the disclosure guidelines for pay for performance, CEO pay ratios, and clawbacks. Another significant development, which is under the health reform legislation directly impacting health insurance providers, is under 162M6 of the tax code, the $500,000 cap on the allowable deduction that a covered health insurance provider can take for compensation paid to employees, officers and directors, and independent contractors whose contracts are subject to 409A of the code, whether that provider is publicly traded or privately held. The tax code was amended for this rule in order to prevent insurance companies and executives from profiting when millions of new customers purchase health insurance under the health reform's individual mandate. There are no exceptions to the limit for performance-based compensation, commission, or compensation paid under existing contracts. From 2010 through 2012, a covered health insurance provider includes any employer that is a health insurance issuer receiving any amount of premiums from providing health insurance coverage unless the premiums received are less than 2% of the employer's gross revenue for that year under a de minimis rule. And from 2013 onward, it is covered only if at least 25% of those premiums are attributable to providing health insurance that is considered minimum essential coverage, also subject to a de minimis rule there. This new limit does not apply to current compensation until 2013, but it does apply to deferred compensation paid in 2013 or later for services performed in 2010 or later. Stock options and stock appreciation rights are considered deferred compensation for this purpose, even if granted at fair market value. It's also important to understand that these rules apply on a controlled group basis, so that if any employer in a controlled group of companies is a covered health insurance provider, then any employer in that group may find itself subject to the deduction limit. While the IRS issued Notice 2011-2, which made several clarifications in connection with these rules, many unanswered questions remain, and further guidance and regulations are anticipated. An observation here of the spillover effect of these rules is the proposed bill in Massachusetts, mentioned by Tamar earlier, to limit exec comp to $500,000 a year for certain public charities, and some of the other bills that are pending to cap compensation, strikingly similar to the cap on the deduction found here in 162M6. Another rule that I'll finish with under health reform legislation, which can impact overall compensation of highly compensated employees, is the rule under 105H of the tax code, which prohibits non-grandfathered insured health plans from discriminating in favor of highly compensated employees. Under prior law, it used to be that a self-insured plan could not discriminate as to eligibility and benefits. If this occurred, the highly compensated employee would be taxed. But now this rule has been extended to insured plans, but the penalty here is on the employer at $100 per non-highly compensated employee discriminated against, and the plan can be subject to a civil action to compel non-discriminatory benefits. We're still waiting for final rules in this area. They will not be effective until the regulations are issued, and there are many unanswered questions on these rules. It's not entirely clear how to apply the non-discrimination test under 105H. Historically, it was always troublesome to determine how to do that with the self-insurance plans. You can see on the slide some of the unresolved questions, and in addition, consider the following. What is the basis on which the determination of what constitutes non-discriminatory benefits How should that be made, and what would be included in the term benefits? Will the non-discrimination standards be applied separately to employers sponsoring insured plans in distinct geographic locations? How will they apply to multiple employer plans? Will coverage provided to a highly compensated individual on an after-tax basis be disregarded? And then also consider the severance context and provision of COBRA. Severance arrangements where the sponsoring employer pays COBRA premiums on a more favorable basis than for active employees. How will these rules apply there? What if severance provides for COBRA to be offered for a period of time longer than the maximum coverage period, or variations in COBRA premiums based on location? How will these rules apply in the context of retiree plans? Obviously, there are many developing rules and unanswered questions in the area of executive compensation, and we have yet to see the full spillover effect on the healthcare industry.
Thanks, Michelle. Just in summary, before we get to the questions and answers, what I'd like to say is to summarize a little bit about what you heard and try to alleviate some of the fear you might take away from some of this. And on that topic, what I would emphasize is while compensation for executives in nonprofit organizations and healthcare institutions is under scrutiny, it is a justifiable and recognizable fact that those executives are valuable in general, and that oftentimes organizations, because of their multiple facets, are competing with for-profits that may not have the same kind of constraints that we've talked about, or may have other kinds of limitations that don't really affect healthcare institutions, nonprofit healthcare institutions. The bottom line as lawyers and consultants in this area is that if compensation is done properly, if the rules, so to speak, are followed, if you follow the suggestions on best practices for determining reasonable compensation, that does satisfy the obligations of the organization in this area. It is certainly defensible, and when it comes to the knock on the door, and whether that knock on the door is a regulator or a reporter, you're in a good position to say, not only did we, quote, follow the rules, but we have a real strong justification for why these individuals are being paid what they're being paid. With that, I'm going to turn it back to Vicki for a few instructions, and then do some questions and answers. I see we have a few questions that have been posted. Vicki?
Great. Thanks, Robert, and thanks to our presenters. As you mentioned, at this point we'll stop and take questions. If you have not typed in your question yet and you would like to do so, please be reminded that you can do so by clicking on the Q&A button on the menu bar at the top of your screen. Then type your question in the box and click on Submit. Real quick before I hand it back to Robert to start taking our first few calls, I did notice that there's a good handful of people that were asking again if they'll be getting a copy of the presentation. You will indeed be getting a full copy of the presentation following the event. So Robert, why don't you go ahead and take our first question.
Okay. The first question, and I'm going to look for volunteers without kind of appointing anybody who wants to say anything, is what impact in general do you think the healthcare reform will have on executive comp and incentives, particularly in the area we touched a little bit about pay for performance and long-term incentives. But can you give us some examples where you may think that healthcare reform in general may have some impact?
Yeah, Bob, this is Kevin. A couple thoughts on that. First of all, I mentioned earlier that almost all hospitals, health systems have some sort of annual plan. Without any commentary about your own plans, I can say, having looked at literally hundreds of these, they're fairly predictable and usually focused on things like CMS core measures, patient satisfaction scores, or age caps and margin, and a few other quality and patient stat measures we'll see. Very few organizations have long-term incentives. Those annual incentives are not addressing first of all, the issues around healthcare reform, but also a difficulty even, incent change within a one-year time frame. So one of the things we're keeping a very close eye on, and this is speculative, but I expect there to be at least more discussion, if not more use of long-term incentives. When you have a timeline for a change, make note about it, there's significant change coming, whether it's, exactly as what's written now or some version of it. There's change coming in healthcare reform. You need to have, and you want incentives to align with that, you're going to have to look at some sort of long-term incentives, or at the very least, long-term strategic plans that then you build your annual incentives out of that. I think that's one of the biggest changes you'll see in terms of how pay is delivered. Anybody else?
Michelle, from your perspective doing executive comp, where do you see the balance then between short-term and long-term incentives? Are organizations moving to that look back of multiple years? Are they looking forward to, what I see is, in terms of long-term incentives, is two kinds of incentives. One is the measurement period being a subject of the longer-term incentive, and then incentives that go out for a longer period of time. Where do you see that becoming a developing trend?
Yeah, that's definitely been a trend for a while now, and especially with the Dodd-Frank legislation, you see the prohibition, especially in the financial industry, against inappropriate risk-taking with respect to incentive compensation. And so where this could directly impact the same concepts in the health industry with reasonableness, and not, taking money, for example, from Medicare and Medicaid, and then inappropriately profiting from that, it certainly is the same spillover effect there.
Okay. Any other, from an integrated perspective as consultants, where do you see the use of long-term? Again, are you looking at measurement periods looking back farther, or are you seeing more development of incentives that really tie an individual to a longer term with the organization?
I think this is Mark Wade. I believe it is going to be on a forward-looking basis. Again, this is speculative, but as you look at healthcare reform as it exists today, we don't know how that will look in 3 to 5 years, but it is, I think most people would agree, we have to fundamentally change the way we're delivering health care. And many times, short-term incentives and long-term incentives can actually be a little bit in conflict with each other. Organizations have their annual incentives because they have to hit their quality measures, they have to hit the patient satisfaction scores, and they have to hit their margins. As organizations take a look at building an ACO, or what do they want to look like 3 to 5 years down the road, they may have to sacrifice some of the short term. So by putting in a longer term incentive plan, it helps balance and keep them focused both on day-to-day operations as well as getting the system ready for the next generation of healthcare.
And let me add another aspect to that I've seen is the longer term incentive, which we really don't talk a lot about, but has a dramatic, or at least a decided effect on, is retention. That individuals where long-term incentives are put into place, they act as significant inducement to stay with an organization, for that organization to retain that institutional knowledge for a longer period of time, because the longer-term incentive really helps bind that person longer than a year or 2 years. There's a real retention aspect to those incentives. Our next question that we've gotten is to focus a little bit on recent IRS guidance on the disclosure, the advanced disclosure and review of the 990 by a board of trustees. And the question was, where does that come out to? Are you disclosing it to just the executive comp committee or even an executive committee of the board, or is it to the full board? Tamara, what do you say?
Well, my thoughts are basically that when the IRS revised the Form 990 a couple years back, one of the biggest goals was to try to improve the governance of nonprofits. But even though the IRS doesn't have the authority under the Internal Revenue Code to regulate governance, they figured that by asking certain questions on the 990, and you have to make a public answer to that they would pressure organizations into adopting what they considered best practices. So among those, they felt that the board of directors of a nonprofit should take responsibility for knowing what's on an organization's 990 and for all the different tax compliance obligations that are on the 990. So in the new governance section on the 990, there's a question that specifically asks, was a copy of your final Form 990, the final version that was filed with the IRS, was it made available to the board of directors prior to actually filing it? It's interesting, the instructions say it could have to be a final version of the 990, not an earlier draft that your accountants might circulate to accommodate the scheduled date of a board meeting. But it's literally a yes or no question. The 990 then also asks you to describe your 990 review process. And that's where it's really important to have a process that you're proud of and that you also describe well on your 990, where you show that either the full board or a segment of the board, such as the compensation committee, has taken responsibility to really review the 990 in detail and make sure that it's accurate before filing with IRS. Now, of course, the board or the compensation committee may want help from, their compensation consultants or their attorneys, and we provide that kind of advice all the time.
And let me add to that there's what I'll call a bleed over from the for-profit world, although to the extent that you've done any kind of bond transactions, you'll understand this as well. But certainly in the for-profit public company area, it is an absolute maxim that the disclosure documents used by for-profit companies filing with the SEC, those are not only reviewed by a board of directors, whether it's the proxy statement, but they're actually electronically signed by the board members as having been read and approved. So this is one of those areas where the IRS may be doing a little bit of catch-up, but as a best practice, it's certainly been a practice applicable to public companies for years and years, and as a best practice, it's certainly valuable for the board, not simply a board committee or a committee of the board, but for the full board to review that final 990 and really become comfortable and confident that what's disclosed there is, in fact, correct, accurate, and it enhances their knowledge base. I think that reaches the end of our time. We're just about done. Vicki, you had some closing remarks. I know you had commented on issues. I'll just, as a closing remark, mention that the slides will be available. Also, there are some additional reference materials that are available in this slide. You'll see some references to that. In addition, there'll be other things relating to a variety of information that you can get from either Integrated or Epstein Becker. I'm sorry to say that one of the things that is not mentioned here, but I will promote because it's not published by Epstein Becker, but there is also a pamphlet-type book, actually a book related to best practices for a board of directors called Answering the Call. I'm plugging it because Lynn Snyder, one of my colleagues and partners, and I are the co-authors of that. It's published by a separate organization. If you go to the Epstein Becker website, you can probably find a link to that book. It's available for purchase. If you were to ask Lynn, where can you get it, she'll tell you, don't buy it from Amazon, buy it directly from women's business leaders in the U.S. healthcare industry, because then all the money goes to that charitable organization. And with that, that concludes the panel remarks. Vicki, do you have anything as a final statement?
Just a couple other remarks. As you said, yep, everybody will be getting a copy of the presentation. Included in that will be some of the additional slides you can look at in your own time that you scrolled through quickly, Robert, as well as some other reference materials and information on our two hosting firms here. And finally, the only other note is that if you would like to see a replay of today's webinar, we did record it, and it will be available on both the Integrated Healthcare Strategies site as well as the Epstein-Becker Green website. So you can go there in the following days and catch a replay if you'd like. Thank you for joining us today. We hope your time was well spent, and we hope you enjoy the rest of your day. Thank you.
Thank you very much.